I am Leon Forsman, the CEO of New Dawn Mediation Services. Today I would like to talk to you about commercial mediation as a way of dealing with disputes in and outside of your company. But first of all, if you like this content, please subscribe to my channel and press the like button so that you can be reminded of new contents being placed on the channel. Why would you consider mediation at all in any dispute? First of all, I need to say that it is voluntary. There is no gun against your head to use mediation as a way of resolving your disputes. Secondly, it is flexible. During the whole process of mediation, you are in control of the outcome of that mediation. And it can be a very unique and way in which to deal with the problem at hand. I also need to underline that any form of mediation is confidential. And about this confidentiality, I will say a bit more as we go along. Commercial mediation has at its core a neutral third party, which we call the mediator. The mediator assists the parties to work towards negotiated settlements of their disputes. It's also noteworthy to note that mediation is without prejudice. This implies that nothing said or written in mediation can be used in a subsequent court proceeding. So it helps along the whole process of communicating open and directly to one another without the fear that what is said can later be used in court. Commercial mediation provides a private forum in which parties can gain a better understanding of each other's positions in the dispute. And they can start working together to explore unique options to resolve that conflict or dispute. There are many benefits to commercial mediation. First of all, I would like to say once again, it helps grow the understanding between the parties about what is really on the table, what is really the issue at hand. And it helps create a clarity of each party's perspective. It can help, and I think this is very important, preserve a business relationship that has grown over many years and which is in the best interest of both parties, that relationship does not fall apart. The confidentiality avoids embarrassing information becoming public to people. And here it is noteworthy to say that the confidentiality comes about in two ways. One, the whole mediation process is conducted in private, and the content will only be publicized in the event that all parties agree to it being made public. So absolutely everything said, everything written, even the agreement stays confidential. Secondly, the confidentiality comes about in the sense that it allows parties to communicate, as I've said previously, with the mediator without the risk that the mediator will pass information from one party to the other. Parties can agree on solutions which a court would not be able to order. The caveat here is that we may not agree on criminal conduct in such a mediated agreement. But there is a lot of leeway otherwise to come to some form of unique agreement between the parties to settle their dispute. It is usually also not a very long process. So therefore, mediation saves a lot of valuable time and, of course, then money as well. Another advantage of mediation is that it is strictly without prejudice. So information that was provided during the course of the mediation proceedings may not, as we said during our discussion of confidentiality, be used by the other party in a subsequent court proceeding. How does a typical mediation process look like? It starts where the two parties agree that they would like to mediate the dispute, that they would like to come to some kind of arrangement without litigation. When they have decided to mediate and they've decided on a mediator to help them through the process, the parties would send the mediator all the relevant documents and, very importantly, a statement on their position they hold before the mediation starts. This helps the mediator to understand what the dispute is all about. And he or she may then already form form the mediation in a way that is conducive to reaching an amicable resolution to the dispute. Then a mediation session is arranged on a time and day that suits all the parties. And the parties from both sides attend the meeting. They can do so with or without their legal representation. It is also very important to note that the persons that attend the mediation also be mandated by the different companies they represent to be able to make a decision, to be able to come to a conclusion of the dispute. They must be mandated with the authority to sign off on the mediated agreement. The mediator will then, during the process, facilitate it and help the parties to reach an amicable resolution to their dispute. The settlement can then be drafted and the parties can go through it and decide whether it reflects what was reached, the agreement that was reached during mediation. Then that settlement can be made an order of court. For it to be enforceable, it is suggested that it be made an order of court. You may be wondering, what is the status of commercial mediation in South Africa? Quite interestingly is that mediation is becoming more and more to the foreground as litigation becomes more and more expensive and time consuming in terms of reaching an agreement. There are over 50 statutes prescribing the use of mediation as an alternative means of resolving disputes in South Africa. Parties may opt for mediation in all civil claims. They are open to do so before they start or go the litigation route. The Labour Relations Act of 66, 1995 requires parties in a dispute to mediate. Therefore, we have in South Africa the CCMA that deals also with mediation and disputes regarding labor issues. Mediation also plays an important role in divorce and family matters, and the Children's Act of 38, 2005 actually prescribes that where there are children involved, that mediation is advised. The Constitutional Court of South Africa has advocated the use of matters relating to commercial agreements and or evictions to be mediated. The Protection of Investment Act, the Act of 22, 2015, also prescribes or tries to get litigants to a point to rather mediate their differences. The Companies Act, Act 71 of 2008, and corporate governance directives such as the King 4 report all make provision for mediation as an alternative to litigation. Then there is Rule 41A of the Uniform Rules of Court that dictates that every new action or application in the High Court must be accompanied by a notice indicating whether the relevant parties or either side of the litigation, agrees or opposes referral of the dispute to mediation. You can see that mediation is becoming commonplace in South Africa and in dealing with disputes. It makes justice more accessible to more people. It helps more people to find justice in their circumstances and in their disputes with each other. You may ask, what can be mediated? The simple answer is anything, any dispute, any conflict can, to a certain degree, be mediated. When we talk about commercial mediation, disputes between shareholders and directors can be mediated. In cases of professional negligence, mediation can be used. Partnership disputes, construction disputes, property disputes, sectional title disputes, inheritance disputes trusts, and many more can all be mediated in some form or shape. You may have listened now to this video and you have some questions. You are more than welcome to contact me. I will leave my cell phone number in the description below, and you're more than welcome to phone me. If you are interested in mediation and would like us as a company to help you resolve your disputes, contact me. I will leave all my contact details, including my email address, in the description below. Given the advantages of mediation, it just makes a whole lot of sense rather to mediate than litigate. Thank you for listening, for taking the time. May all your disputes be resolved through mediation. Thank you. Goodbye.